Hello friends, welcome on the channel. In today's video, we will discuss about the legal aspect of the public procurement. So this is such a topic that I think that we should make a video and make you aware that when you are doing the public procurement, so which are the legalities involved, which acts, rules, instruction from the legal point of view are related to that. So I will try in this video to make you aware about that. So let's start. So today's topic is legal aspect of the public procurement. As you can see that as per the Constitution of India, every bidder is having a right of equality. Our Constitution gave every bidder the right of equality for doing business. So it is a fundamental right. As per Article 19(1)(g) of Indian Constitution, this right is provisioned there. So in India, everybody can do business and its foundation laid in Indian Constitution. And in public procurement parlance, only authorized officials can make and execute contract on behalf of the government. You might have seen that when some order is being issued, it is being issued in the name of the President of India, or in the state government, it is issued in the name of the governor. So, as per Article 299, Part XII, all contracts on behalf of the union government or state government has to be entered into and executed by the authorized person on behalf of President of India and Governor of the state. So from here, this power comes that on behalf of President or on behalf of the Governor, the officer at central government and state government, they issue orders. So they are having delegated powers. So this is the way of doing business, and this is provisioned in the Indian Constitution, Article 299. Indian Contract Act 1872. So in the most of the public procurement processes, this act is very much relevant, and I will recommend you to read this act if you have time. So there are many provisions of this act in the procurement which are being referred. So Indian Contract Act 1872 is related. The next is the Sales of Goods Act 1930. Other is Arbitration and Reconciliation Act Amendment Act 2021. The Competition Act 2002, MSME Act 2006, IT Act 2000, CVC Act 2003, Delhi Special Police Establishment Act 1946, that we call CBI. So you can see how many acts are there which are related to the public procurement aspects. So in different way they affect your decision or the procurement process. Next, you can see Prevention of Corruption Act 1988. It is a compilation. I have compiled it for you. The Foreign Trade Development Regulation Act 1992. The latest Exim Policy 2023 to 2028. Foreign Exchange Management Act 1999. Foreign Exchange Management Act Current Account Transactions Rules 2000. So these were the acts I have shown you which are related to the public procurement. Let's see other aspect. So what is a contract? As per the Indian Contract Act, what is a contract? So it is a proposal or offer. Somebody proposes something to some other person or give offer to some other person, and the other person he accepts that offer or proposal. Then it becomes a contract. A proposing to B something and B is accepting the proposal, so it is a contract. What agreements are contract? We will see here. When when the parties are doing contract, so they should be competent enough to do the contract. It should not be like that the incompetent person he entered into the contract, that will not be a valid contract. Suppose the CEO of any company is empowered or he has empowered any official to enter into contract. But while signing the contract, the peon of that office he signs, so he is not having the powers or he is not competent. So the contract signed by him, the peon of that organization, being a non-competent person, will not be a valid contract. So only competent parties can enter into contract. Freedom of consent of both parties. It means whatever parties who is going to enter into the contract, they should be free. It should not be that somebody given some pressure of any kind and then get his signature or enter into the contract, or on basis of some gunpoint or some other thing. So you push someone or you force someone to sign into contract. So that will not be a valid contract. So the parties who are entering into contract, they should be free. Lawfulness of the consideration. It is very important point when both parties are agreeing for anything. So that should be lawful. It should not be any illegal activity. So if any illegal activity is being taken as consideration, that will be a invalid contract. So the contract should have legal valid considerations. And lawfulness of object. The object of the proposal should be also lawfulness. It should not break any rule or break any law. So these are some basic nature of the agreement or contract, which I have explained here. Categories of person. What are the persons or individual in the eye of the law who can enter into contract? So first, individuals. Individuals can enter into contract. They are individuals, and then partnership. Through a partnership, the contract can be agreed. And in case of public limited companies can enter into contract. Such entities, limited company or partnership or corporations other than limited companies, they are legal defined persons. So in the legal language, they are having independent entity, irrespective of their shareholder or the who is the owner of the partnership. Okay. So these are the categories of officials who can enter into contract. Consent of both parties. Both parties who are going to enter into the contract, they should understand the contract in the same way. Otherwise, it will not be valid contract. And they should agree upon the same thing in the same sense. Suppose A is proposing to B something and B don't understand A's language. So he's not getting whatever the sense or whatever the thing A is saying. So being ignorant with that, and if he enters into the contract, that will not be a valid contract. So both parties should agree upon the same thing in same sense. And free consent of both parties should be there. Both parties should be there. There should not be any type of pressure. So they should be free to think and to take decision and competent also. Next is ignorance of law is no excuse. The legal system in India operates on the principle that ignorance of the law is not a valid defense. Therefore, a mistake about a law does not negate the contract. So, if you don't know any law and you enter into a contract and that is an valid or invalid contract, so you can and if you become somewhere in problem due to that contract, so you cannot have an escape route saying that I was not aware about the provision of that particular act, so I was not knowing it. So ignorant from the law is not an excuse. Being a citizen of that land of law, so you are supposed to know the rule. So ignorance is not a rule. Mistakes regarding foreign laws are treated differently. The above one I told about the Indian laws, and mistakes regarding the foreign laws are treated differently. They are considered mistake of fact and can potentially make a contract voidable. So the Indian law system and the foreign from the point of view of foreign laws, things are differently interpreted. I can give you example of that. If two parties enter into a contract based upon a misunderstanding of a specific Indian law, the contract shall be valid. However, if they mistakenly assumed a foreign law was applicable and made a mistake based upon that, the contract would be voidable. So here it is clearly mentioned here in this example that if two parties enter into a contract based upon misunderstanding of a specific Indian law, the contract will be still valid. So ignorance is not an escape for them. But in case of foreign law, it is the things is not same. Regarding the consideration, so the consideration should be valid. The parties who are entering into contract, they should have a valid consideration, and which means something of value, like money, a promise, a service, or an act. It can be a value which is being exchanged under the contract that is given at the desire of the promiser by the promisee or any other person in return of a promise. It can be a past, present, or future, but it must be lawful and real. So here you can see a very clear, valid consideration at its content. It should be valid. It can be past, present, future. It should be lawful, and the thing should be action. It can be money, service, promise, or an act. Example: if A agrees to pay rupees 1,000 to B, and if B delivers a book to him, B's act of delivering book is a valid consideration for A's promise to pay. So this example clearly defines its considerations. The communication of a proposal. When one person who is the proposer makes an offer to other person to the offeree, the offer is not considered communicated until the offeree actually knows about it. As I earlier told, the person to whom the proposal is made must understand the same thing in the same sense as intended by the proposer. Means whatever proposer is saying, the proposee or the offeree, he should understand and uh, understand the same thing in the same sense. Then it will be proper communication of the proposal. In case when A communicated to B A communicated in a language to B, which the language we don't know. So that will not be a valid consideration or valid communication. So communication should be effective and it should be understood by the person who is listening in the same way the person who is communicating. So it is very important point. I will give example here. A says to B, I will sell you my car for rupees 2 lakh. A is offering to his Hyundai Verna, but B thinks that A is offering to his Honda City. If B says I accept, thinking it for the Honda City, but A means the Verna, there is no valid contract because the thing A is saying and the thing B is understanding both are different. So there is no valid contract because both did not agree on the same thing, the same sense. I hope this example clears this communication, proper communication of the proposal. So here I try to here I try to define some basic understanding about the legal aspect and what are the laws related to this. So since every law is having a considerable uh, reading and understanding. So it will take time to go in detailing with those. So at this moment, just to give you an idea that these are the laws. If you wish, you can go in details. Or if any one of you can say that we have to make some specific video related to some specific law and important points, we will try to make. So if any such thing is there, you let us know. So thank you for watching the video. Have a nice time.